Welcome to The How of Business with your host, Henry Lopez, the podcast that helps you start, run, and grow your small business. And now, here is your host.
Welcome to this episode of The How of Business. This is Henry Lopez, and my guest today is Danya Shakfeh. Danya, welcome to the show.
Thank you for having me.
Danya's an attorney, and so she's with me today to share some insights. And in particular, she's an attorney, but she specializes in particular in mergers and acquisitions. So she's going to share some general guidelines, legal perspectives, kind of insights, experiences from a legal perspective as it relates to buying or selling a business. We'll probably focus on it a little bit more from the buying side, but we'll kind of try to go back and forth from both perspectives rather. But we're going to discuss what are those legal considerations that apply when we're buying and selling a business. We've talked a lot about on this show, and I've had lots of guests talking about the business side of that, the transactional side of that, the due diligence side of that. But from a legal perspective, what are those things that we should look for and hopefully avoid some of the common mistakes that a lot of people make? To get more information about the How of Business, including the show notes page for this episode, and to learn more about my one-on-one coaching and group coaching programs, please visit thehowofbusiness.com. I also encourage you to please subscribe wherever you might be listening to this show so that you don't miss any future episodes. So let me tell you a little bit more about Danya. Danya Shakfeh is a business law attorney and the founding attorney of Motiva Business Law, which is based in Oak Brook, Illinois, but they also have an office in Tampa, Florida. And very succinctly, she helps clients get deals done so they can focus on their dreams of business ownership or of having realized an exit of their business. And so her practice focuses on mergers and acquisitions, franchise law, contracts, and corporate startups. Danya, once again, welcome to the show.
Thank you for having me once again. Thank you.
Absolutely. So we'll jump right into it. But before I do so, let's just do a quick legal disclaimer. I'll share the disclaimer here, and then you can add whatever I'm missing there. Danya is an attorney, but she's not your attorney. And so we're just going to share general guidelines here, best practices, principles, experiences, but everybody listening should get their own legal counsel before you take any actions related to anything that we talk about. Anything that you would add to that, Danya?
That was perfect.
Excellent. All right. So having said that, let's dive into it. I want to kind of walk through the process, I thought, and that'll then kind of spawn questions and go off on it. So I kind of laid out in my notes, as you probably can see, what I typically think of or what I typically follow as the high-level steps in the process of buying or selling a business. Initially, it's that exploration, that research, that then when we've got a business that we're interested in, typically I've found that people want you to sign an NDA, right?
Yeah, especially because the seller is going to be sharing some pretty sensitive information. In particular, finances is something that they really want to keep secret. So that's why they want buyers to sign an NDA.
Often if I'm looking at it from their prospective buyer's view, what should I look for? What are some cautions there that I should and have my attorney look at before I sign an NDA?
That's a great question. I think one misconception about NDAs in general is that they are just a template and they're all the same. But I've reviewed so many NDAs and I've never seen two that are the same. So definitely people should be a little bit cautious, especially if there's a lot of sensitive information being shared. But probably the biggest thing that a buyer should look out for is to make sure that the NDA is not overly broad and does not put too much burden on the buyer to hold information or the consequences of learning information. So for example, anything that, so if the buyer learns of, or like if they have access to financial documents and they're expected to hold them for 3 years and then, so this is like this really long time period where the buyer could be responsible for any potential claims. So that's one issue that I see. And then also like so much liability, like if the buyer breaches, then the seller has like so many remedies, probably remedies beyond what is expected in that time period.
I see.
And then also I've seen sometimes NDAs, especially if people use templates, is that the NDAs start to cover other aspects of the deal.
Okay.
And so you don't want it, so you want to make sure that whatever you're being, as a buyer, like whatever you're being exposed to, or excuse me, that the NDA is going to be limited to whatever you as a buyer is exposed to. There's no other obligations or, liabilities. So those are probably the biggest issues I would look for on the buy side
Okay.
in
Yeah,
an
that
NDA.
makes sense. So not too broad, some time specificity to it, some term to it. Those kind
Right.
of things are critical. I reminds me, I was presented with an NDA once, this was years ago. I was evaluating a potential franchise, and the
Mm-hmm.
franchisor, I still am amazed by it. I don't even know if it was legal, but none, and of course, shall not be named. But
Yeah.
in there was a stipulation that I was agreeing not to consider any other franchise competitors.
Yeah.
And that was, again, don't know if it was legal. We're not going to make that judgment here, but that was an example where that would have really restricted me then to not be able to consider any other franchise. And I wasn't even anywhere near to making a decision on this particular franchise.
Yeah. So that's them kind of sneaking in like a non-compete in the NDA. You really
Correct.
just
Yeah.
wanted to make sure it's a non-disclosure and that's it and nothing else.
Yeah. Don't
Absolutely.
know how enforceable
That's
it
a
would have
great
been, but
example.
nonetheless, those are kind of things. All right. So then as we begin to do our research, our review, typically where we focus is on the financial side, analyzing the business operations. What do the sales numbers look like? Who's the clientele? What are they selling? From a legal perspective, what are the things that early in the process maybe I should start thinking about?
Probably the structure of the deal, which could vary, later on, but you want to know early on if it's going to be an asset sale or a stock sale, because that's also going to that is going to guide your due diligence. If you know that, as a buyer, you will be buying the stock, for example, then you want to make sure that you know of all potential liabilities of the actual entity. Whereas in an asset deal, those are not necessarily going to be in play. Another aspect which may be overlooked, we actually had this issue in a recent deal, is you want to make sure that the sellers who are selling the business have the consent of all of the people that need to give their consent. We were in a situation recently where there was like a surprise business partner at the 11th hour before closing, and we had to stop the deal because now this like surprise business partner was claiming that they have to also have a say in the transaction, even though as the buyers we did the due diligence, but the seller was not very transparent on that respect. So just get really clear about all the parties, check out the operating agreements and make sure that that's not going to be an issue later on. So those early on are the things that I would look to at first from a legal. And then also any contracts. And the reason why that's important is because the contracts are going to signal the revenue and the liabilities of the business. So especially in a referral-based business where there are contracts involved, you want to make sure that those contracts are transferable to a buyer. And so those are probably the biggest three things that I would see.
Yeah. I want to come. I want to come back to the point because I was just giving this thought with a client of mine who's looking to buy a business. Is that point of who has the authority to execute the sale, and is everybody involved? So the only thing that I would know to do, as you're alluding to, is to review or have my attorney review the current partnership agreement or operating agreement to see who are the owners, right?
So what we do sometimes too is we check with the Secretary of State. But that varies from state to state, because so if you see a name on the papers that are publicly available, and again, it's not always the case with each state.
Right.
That helps us to see to see if a seller is providing all of the information that they should. So in this case, we actually did see an operating agreement, but apparently it wasn't the latest version.
Yeah.
And so, so I mean, in our practice now, I mean, so even online, like there was no indication that this, business partner was existent. So, and then sometimes maybe just doing a Google search and going on
Hmm.
LinkedIn and see if there are any potential people pretending that they own the business, just to kind of cross-check to the extent that you can. I mean, sometimes if someone or if a seller is not being transparent, there's only so much you can do, but at least
Right.
the buyer has done their due diligence. Yeah.
Absolutely. Yeah. The other thing is the good old fashioned asking questions. I always like to
Yeah.
ask early in the process. So who will be involved in this decision process? And then I'll ask it multiple ways
Yeah.
if I'm suspicious, right? And
Hmm.
and eventually, yeah, there's Jamie, but he's not involved in day to day, so he'll be fine with it. Well, that's a yellow
Yeah.
flag, right?
Yes. Yeah.
Yeah.
That's a yellow flag. Yes.
Yeah.
And sometimes it could actually be the opposite. We've had deals where as we dug into it and the documents, we saw that a party, business partner, or whomever did not necessarily need to consent, which actually makes things easier for us. So it's always
Sure.
good to know, on both ends so that you don't have any like people who are claiming rights that they really don't have, a
Right.
right to.
Right. Going back to the asset versus legal entity purchase or versus stock purchase or unit purchase, in my experience, and I've done both, but
Mhm.
my mode of thinking is that it is usually disadvantageous to a buyer to purchase the legal entity as opposed to just buying the assets. Is that
Yeah.
generally true?
Yeah. So we have an expression that the buyers buy assets and the sellers sell stock. We can't have it both ways, obviously, in
No,
the same
exactly. And
transaction.
therein lies the negotiation and the conflict, right? That we're
Yeah.
trying to settle and
Yeah.
agree to. Yep.
But that's kind of where yeah, so I mean, in general, yeah, so buyers want to buy assets because of the liability not transferring, but there
Right.
are situations, especially if we find that those referral contracts can't transfer to a new
Hmm.
buyer or there are certain
Hmm.
limitations, then maybe a stock sale would actually be like advantageous because you don't have to worry about the contracts being transferred to the buyer.
And I mean, that
Yeah,
could
and
apply
then
to a vendor relationship. Let's say I have a
yeah.
relationship with a large retailer.
Hmm.
If there's a change of ownership, that may have to start all over again, right?
Yeah.
Now, there
Yeah.
could be clauses in
Absolutely.
that contract that would trigger it anyway, but those are another example where it might be beneficial. But this
Hmm.
liability point is the big one, is my
Right.
understanding, that if I buy the legal entity and 3 years ago there was an unsettled matter that wasn't disclosed or uncovered, that becomes mine. Yes.
Yes, absolutely. Yeah. So if there's any like government compliance issues too, that might be another big one. Taxes, that's another big one too. So definitely, I mean, ideally the buyers do not want to take over the past liability. Because even with due diligence, you just never know what's going to pop up.
From a governmental perspective, though, if that previous seller, let's say it turns out, hadn't paid their payroll taxes and we did not uncover that, but I only buy the assets, am I still exposed to potentially being
Yeah.
liable for that?
Yes, because the government will always find a way to get their taxes.
Yeah. so so there's no
So
escaping that, probably,
there's
is
no
what you're.
escaping the taxes.
That's what I figured.
But yeah, so basically, the if there's any liens, or the government actually will also attach the taxes to the assets being transferred, and
Right.
that's why it's important for a buyer to do a bulk sales notice and actually get a clearance from the Department of Revenue, in their state to make sure that that's not an issue. And that's something that's really overlooked by a lot of buyers because they
Mhm.
don't. Because they automatically assume, well, I'm not buying the assets, so the
Right.
taxes don't transfer. But that is something that needs to be done in analysis. So
So it sounds like that's kind of very similar or equivalent to what I might do when I buy a piece of real estate, where there's a title search to make sure that
yes,
title can transfer cleanly. There's no cloud on the title. Similarly, here,
exactly.
I got to
Yeah.
make sure there's no liens or any other demands on these assets.
Yep. Yep. Definitely. Yeah.
Um, Similarly, I was thinking that, most states have a workforce commission, and if that seller has an issue or hasn't paid into that, that's another entity that could say, well, they're your employees now, so you have now incurred that liability. Is that generally true?
Yeah. So I mean, I don't know if it varies from state to state, but in Illinois, we for the most part that will cover both, like in our Department of
Mhm.
Revenue.
What is it that then my attorney at a high level is going to do for me here in this area of that exploration of that research to make sure that, as far as we can tell, there
Yeah.
aren't any of these potential liabilities.
Right, that's correct. Well, okay. So first and foremost, you want to explain to the parties exactly what the process is to get clearance on this. So, because I think too, what maybe a lot of sellers don't realize is that when a buyer can check with either Department of Labor or like the Department of Revenue, or if there are any county requirements or that involve bulk sale notice as well, is that they might issue a letter to hold some of the purchase price
Sure.
in an escrow. And so, of course, that's going to disappoint some of the sellers, but they need to kind of be prepared for that. And so, an escrow agreement should also be prepared in that event. But you want to make sure, basically, the summary is you don't always rely on the seller themselves to tell you what their liabilities are. Like your lawyer should find out on their own from the horse's mouth, which in this case is the government or whatever department the
Mm-hmm.
seller is up to date on their taxes,
Yeah.
and other liabilities. So if the seller says, no, we don't have any lawsuits, well, you want to go check, all the public records involving lawsuits and making sure that's actually the case.
And that is a perfect example of why it makes sense to engage your attorney or an attorney
Right.
to help us with this step of the process as we're
Mhm.
vetting a business. Going back to the escrow thing, I've done that most recently, and these, I typically see this in larger sales, whatever that means, right? But
Mhm.
we had a situation where we sold the business, and X percentage, I think it was 3% of the deal, was held back for 3 years for those same things. Anything that we might have misstated or that was missed, or any
Yeah.
kind of liability issues, and then that money was released to us back after the 3 years. So common practice there. Yeah.
Yeah, so so that's like a holdback, which is a little
Yes.
bit different
Okay.
than the
Okay.
tax, because the tax usually is cleared. Because what often happens is that if the business happens sort of in the middle of a quarter, then could just be a matter of the seller not having paid the taxes because it was not due, not because that they're in breach of anything or they don't owe the
Right.
taxes.
Right.
And then like within maybe a few weeks or maybe a couple of months, like those funds can be released. But yeah, there is a deal where you have a lot of liability or there's a lot of risk involved. That holdback clause is a really good tool to keep some of the funds to protect the buyer, and so
Agreed.
that the buyer does not actually have to go and sell. It's kind of like a self-executing right, instead of having go sue. I apologize.
Exactly. Instead of having to go
Yeah,
back after the seller
yeah,
after the fact,
yeah,
which, who knows where they are, what money they have or don't
exactly.
have. And so you could get
Yeah,
nothing in that case. Yeah.
yeah. So
Yeah. You
yes.
were also talking about, what I have called, and we'll get to the purchase contract in a moment, but
Mhm.
reconciliations, right? So
Yes.
you're going to agree, hopefully, as a clause in the contract to reconcile those expenses as of the
Mhm.
date of closing. Yeah.
Yes.
Okay. But before we get there, what else? What else in the legal due diligence side? So if we're looking at the time frame, I'm a buyer, I've signed that NDA, I've been given access to all the financials, I've engaged my attorney to do this other due diligence. Is there anything else kind of at a high level that you see people will miss, or that is another thing that an attorney can help with on the legal due diligence side?
On the legal due diligence, no, I think that's pretty much it. Just the
Okay.
contract and compliance as well. Like if there are any licenses that are required by the seller, and you want to make sure that they've been compliant
Mm-hmm.
and at least the buyer. So sometimes for example, if you have a liquor license, that's attached to the individual, not necessarily the business, at least here in Illinois.
Right.
So the buyer has to go make sure that they comply. So those are the
Mm-hmm.
biggest issues that I would see.
Yeah, yeah, it's licenses is a big one. Like I bought an existing salon suite business in Texas, and as in most states, at least in Texas,
Hmm.
the salon itself has to have a license, and if they had any kind of issues with performance or violations, it probably would have created a problem for me to get my license because it's by the location, right?
Yeah.
So those are things that we had to look into to make sure that that salon license was in good standing.
Yeah, I think one thing that comes to mind too, still like related to compliance, is like environmental. So if you have like a car wash,
Mm-hmm. Which is a
or
business I
anything,
was in.
yeah, yeah, it involves waste. You want to make sure that the seller was compliant, not just from a legal perspective too, strictly, but also the buyer will know, for example, if a car wash is built properly and that it has the ability to comply, because you are buying that asset. And so if there's like pipes that are not done correctly or what have you, then that's also an indication as to the value of the assets and any potential liabilities that would get passed on to the buyer.
And there's things that could come into play there where the previous owner might have been grandfathered because the rules or the code changed, but now I trigger that again by buying that asset, right?
Yep. Yeah, we had that issue too.
Yeah, that happens.
Those are fun.
Exactly.
Yeah.
This is Henry Lopez, briefly pausing this episode to invite you to join me for one of my next live online workshops. During these interactive workshops, I cover a specific topic that will help you with starting and growing your small business. Just visit thehowofbusiness.com to learn more and to register. If you need help creating an effective business plan, for example, to start your first small business, then my next business plan workshop may be just what you need. Or perhaps you need help completing your financial projections for your new business. Well, I have a workshop for that too. And if you're already operating your business, then you can probably benefit from learning how to better manage the cash in your business by attending my cash flow management online workshop. These are just a few of the workshops that I currently offer, and I keep these workshops to a small number of participants so that we have the time to answer all of your questions. Whether it's getting started with your first business or growing and exiting your existing small business, I can help you get there with one of my online workshops. To find out more and to register for a live online workshop, please visit thehowofbusiness.com. Take that next step today towards finally realizing your business ownership dreams. I look forward to having you join me for my next workshop. So the other thing, let's get to now, we've agreed, everything looks good. We've negotiated general terms. It's time to put together a purchase contract. And unfortunately, it's often, especially with small businesses, where I see people hesitate wanting to go hire an attorney to do this against my advice. But just give us the lecture here. Why is it so important to have a properly drafted purchase contract? And for me as the buyer, if we continue in that role, my attorney should review it before I sign it.
Yeah, so that's a great, something definitely overlooked by especially smaller businesses. Well, first of all, kind of going back to the asset or a stock sale, sometimes purchase agreement actually doesn't even specify what kind of deal it is, just that they're buying the business, because people don't necessarily, like a lay person may not know that there's even a difference. They just think, oh, they're buying a business.
Right.
And so that's one thing you want to be clear as to what you're buying. If it's an asset sale, you want to make sure that it's really clear what assets are being purchased. But the key here that I find that's overlooked specifically is that you want to really use the due diligence to help you draft a proper purchase agreement and to put in to put in the proper indemnifications and representations and warranties, so that if there's ever a breach or there's ever a problem, you are, as a buyer, have more like remedies, because it was spelled out in the contract. You don't, as a buyer, want to rely on due diligence to come to make a claim against a seller later on, because if anything, it would just be used against you in court, because because the court would probably look at the buyer and say, well, you knew it, but you didn't really.
Yeah, you had every opportunity to uncover you bought this as is, but we're not buying it as is. We're expressing further warranties and remedies beyond the due diligence. Yeah.
Yes. And I think also a lot of buyers who don't use a lawyer don't know all of the options that they have that they could put into a purchase agreement. They think, oh, it's boilerplate, it's standard. I can't really change much anyway. But a holdback clause is a great tool that a lot of buyers don't use when they could, to protect themselves. I don't think people realize that's an option.
That you can do that. Yeah. I think people feel like maybe there's laws that govern this. As long as it's not an illegal transaction, really, it's up to the imagination of buyer and seller if you agree to it and it's a legal thing that we can do, right? I mean,
100%.
There's no limitation on how we can arrange this. Yeah.
100%.
The transition period is often something I also include in the contract. In other words, how long and specifically how the previous owner will help us in the transition period. So you're going to be on site every day at our request for the first month, then the second month, once a week, and so forth.
Right. I
usually like to spell that out in the contract. What are your thoughts on that?
Yeah, absolutely. I think that's really important. Especially sometimes like we had a deal once where it wasn't just or the seller, so it was an asset sale and the seller was keeping part of the business. And so it was the seller himself, and also sometimes he was lending his employees to help with the transition as well. And so you want to get real clear on how, if the seller is even being paid, because sometimes that labor in the transition period is sort of like rolled into the purchase price.
Right.
But if you have other people or like employees involved, you want to make sure and be clear on who's responsible for paying those employees
Mm.
and their taxes and so forth. So absolutely, I do have we have a transitional agreement that we put in there as well.
Excellent. How about non-compete? I usually will, again, if I'm the buyer and now if I'm the seller, I have a different perspective, right? I want to limit that non-compete or have it phase out. But non-compete is something that I usually like to have in there as well, right?
Yeah. So, obviously the seller has built a business that is presumably a success. And so the last thing that a buyer wants to do is that the seller uh, sets up shop across the street with all their
Hmm.
skills
Right.
that would be, in competition. So having a non-compete for the buyer is a great tool to protect themselves. It's also really important to I always like to ask too if a seller is going to be moving or if they're going to stay in the area.
Interesting.
And it's nice to know what they're going to be doing after the sale.
I see.
And so that way you can uncover yellow flags too. If they say, well, I want to stay in the area and start another business. Well, what kind
Hmm.
of business? Because even if the parties sign the non-compete, it doesn't mean that the seller will, actually abide. So
Right.
it's kind of good to really just ensure, it's good to know what everyone's goals are, um, so that you can determine the likelihood of a breach. Yeah, so because we've seen
These
that too.
these types of non-competes, as long as they're properly defined by an attorney,
Yeah,
they are
yeah.
generally enforceable, correct?
Yeah, so there is a general trend in a lot of states, but really in Illinois, not so much Florida, but in Illinois and even at a federal level, non-competes are becoming non-enforceable or harder to enforce, but really specifically in the employer-employee
That's
relationship.
what I thought. Yeah.
And yeah, but when you sell a business, it's not in that realm of non-competes
Mm.
because there is consideration, and it's not, I mean, it's a different relationship.
Yeah, there's
And so it's
consideration,
kind
and
of,
I'm not saying you
yeah,
can't go make a living. You just can't make a living doing
exactly.
the same thing down the street.
Exactly. And plus, like the buyer is like buying the goodwill that's part of the
Exactly.
assets of the
Mhm.
business. And so if the seller just goes and just recreates the business across the street, then the buyer isn't, I mean, the buyer is not like getting the value of what he or she paid for.
Yeah. All right. I want to come back to something that's not as much of a legal, but I'd like to get, since you've done so many of these, kind of your perspective. One of the things that's always tricky, both from the seller and the buyer,
Mhm.
is, do we keep this secret to our staff, to our customers, to, do we keep this secret as long as possible, or do we make it transparent? In my experience, it just depends on the business, the type of business, but what are some best practices or things for us to think about there as it comes to that point?
Yeah, that's a great question. You're right. I think it is case by case, not only by the business itself, but the employees that you're exposing this information to. I think more lower level employees probably would freak out knowing that a
Hmm.
business is going to be sold. I think the
Yeah.
minute someone thinks mergers, acquisitions, the next thing that comes to mind is layoff.
Yeah. My job's going to go away. I'm
Yeah,
redundant. I'll be
yeah,
fired. Yeah.
exactly. There's going to be someone else take my place, or my place is going to be redundant. But on the other hand, a truly ethical, I think, seller would care enough about their employees that they want to give them enough notice because this is their livelihood. So it is like a delicate balance of trying to just be a kind person and not like hurt your employees and fire them like the day after closing without any knowledge. But also, you don't want to scare them. And thinking, wait, like, why is the seller selling the business? Is there something wrong? I would say like hold off as long until like first of all, there's no need for anyone to know unless there's something that's really clear,
Yeah.
that the
Concrete.
seller
That looks
knows that
like
the
it's
buyer is
imminent.
going to
Yeah.
buy.
Yeah.
Yeah, yeah, exactly. And then so I would also say that have that conversation with the buyer, like if you want to have a delay or like to take into account how long you have between the purchase agreement or the LOI being signed and closing, because at that point you know that something has been solidified and you want to give some notice to your employees to maybe perhaps or find a new job or rearrange things for them. So
Exactly.
that might be
Yeah.
a good sweet spot.
Yeah, one of the things that I've done related to that is for my key employees, for my leaders. Once I've told them, I've also told them, and I've got a retention bonus for you. So if you'll stay through the transition, or if you'll stay with us until closing, I'm going to pay you X bonus as an incentive for staying with us and not jumping ship right away.
Yeah.
Because again, I can make no guarantee that the new owner is going to keep you unless we agree to some kind of employment contract,
Right.
which is not ideal. All right, I want to go back to the LOI for a second, because one of the things I wanted to clarify as well, in my experience, and every LOI that I've ever signed purposely is a non-binding LOI. But it doesn't have to be. But what are your thoughts on that? Is whether an LOI should or shouldn't be binding? Talk to me about your experience there.
So yeah, all of I mean, in general, I like that. Well, so LOI itself, the aspect of whether the parties need to move forward and close, that's non-binding, but there are elements in the LOI that can be binding,
Sure.
such as, the confidentiality if it's rolled in there.
Mm-hmm.
I like to also, especially on the buy side, put a no shop clause, basically
Yes.
so that the seller doesn't go and sell the business to someone else while the buyer is doing their due diligence or taking care of the financing. Sometimes the seller wants some escrow in exchange for that no shop clause, which is reasonable.
Right.
And so that's something. So that would be binding.
Mm-hmm.
We did have one situation where the parties they used a broker, and I guess their template was actually binding. It was basically a purchase agreement, even though it was
Interesting.
called a letter of intent.
Ooh.
And it just made things so much more complicated because as we were doing due diligence or as we got closer closing, one, it really hurt the timeline because when people think LOI, they think, okay, non-binding, we have time. But
Mm-hmm.
then all of a sudden you're like bound by this agreement and might
Right.
not have all your ducks in a row. So ideally I would have the LOI to be non-binding except for that or like those parts that I spoke about.
Right. Yeah.
Just because it gives people breathing room and it doesn't stress anyone out. And then you might
Absolutely.
just want to,
And then people, and the pushback, I guess, I'm saying, well, what's the point of the LOI? In my experience, and I'd like to get your thoughts,
yeah,
there are a couple benefits to the LOI, primarily as a negotiation tool. First of all, it formalizes that I am interested in your business. Here are
yeah,
the general aspects of what I'm looking to do. I want to purchase your assets, et cetera, et cetera. I want to, inspect records, whatever it might be. I probably am sharing general terms, the proposed purchase
yeah,
price, proposed terms, whether you're taking a seller's note, those kind of high level terms. I'm kind of putting that on the table. And it's a level of acceptance that, yeah, these terms, generally speaking, are acceptable to be further negotiated later. So it formalizes that. And I think it helps as a negotiation tool, I think, for both sides, really. What
yeah,
are your thoughts?
yeah. I think it's really important. It forces, I mean, so if someone has a good guide, like a good lawyer or a good broker, it forces the parties to have a conversation very early on what their deal breakers are. And that's one of the first questions that I ask my client, like, what are your deal breakers? Let's put that in the LOI, because if the parties know exactly what those deal breakers are, then there won't be any surprises or any loss of goodwill as the parties negotiate or get close to closing. Now, for smaller deals, or if a deal needs to move quickly, you may be able to skip the LOI. I mean, you can always skip the LOI phase, but
Sure.
but if there's like multiple offers or if it's a really high demand business, an LOI is a great tool to use for the seller to figure out who is serious, especially if they are asking for escrow in combination with the LOI. And then same for the and then yeah, so I think it's a great tool.
Yeah.
Yeah.
But I love that perspective of what are the deal breakers. So if for me as the buyer, it's a deal breaker that you're not going to take a seller's note, this gives us an opportunity to either decide that or not, or we'll move on, right?
Yeah. Yeah.
And it could be that I still think I might be able to negotiate or convince you, but likely, at least I know this is something you will not consider at all, and that could be a showstopper for me as a buyer.
Yeah. We know, like we've seen situations where like closer to closing or even close to a purchase agreement, someone brings up a deal breaker and it
Oh,
just really
sure.
sours the deal
Yeah.
and people start to lose trust
Yeah. I mean,
in
I've
each
had it
other.
done to
So
me by
yeah.
a seller as a negotiation ploy, and that is
Ugh.
that's horrible. Yeah.
Yeah, I do not
It is
recommend
terrible,
zero
but
out
it
of five
happens.
stars.
All right. So from an attorney, the pushback, of course, always that I hear, and the hesitancy, I think, for a lot of people looking to buy a small business or looking to sell their business is, boy, I don't want to incur the cost of an attorney. Secondly, although I don't hear it as much of an issue, as I don't want an attorney killing the deal, right? That's always
I hear
the
that from the
fear.
brokers more than the
Yeah,
client.
that's true. That's true.
Yeah.
When should I engage an attorney in this process, ideally?
I mean, ideally early on, at least know when it would be good for your specific deal, because every deal is different. The timeline is different. Because what's happened to me sometimes as the attorney is that my client has come to me after signing the LOI, and they put a really short closing date, and it just made it hard for me as the attorney to actually represent my client. I mean, we were able to get
Right.
it done, but it was very stressful.
Mhm.
The deal actually did not go through anyway, so I guess it was a moot point, but it was still very stressful. And then it's harder to negotiate once a document has been signed. And so you don't want to put your attorney in that position because it will jeopardize your deal. And then sometimes also with like the bulk sales aspect, I mean, people come to me, they've signed everything, but they don't know that like they should file a bulk sales notice. And sometimes the statutes actually have laws around when it should be filed before closing date. And so that just I mean, it just puts everyone in a more difficult perspective, and you lose leverage, on either side.
Got it.
So I would
Yeah.
say the earlier the better, even if you don't fully engage the lawyer. As far as the fee, I like to consider it more like sometimes, so the pushback that I get sometimes is, oh, this is only like $100,000 deal.
Right. Exactly.
Why
It's a
should I
small
spend
deal.
X?
It's a
Yeah,
small,
it's a small deal.
it doesn't make sense for me to spend all this money on legal fees.
Yeah, but then I'm like, well, it's not so much on the size of the deal, but like the risk, because if something were to go wrong, or that, these pro se people did not do it correctly, then usually the buyer is the one stuck holding the bag. So even if it was a small deal, it doesn't mean that your liability is that small. And it doesn't mean that if you had to sue the seller for your rights, that it would cost less than that. I mean, I've seen people excuse me, like I've seen people out litigate the value of
Hmm.
the claim all the time. People will spend, $80,000 for a $40,000 deal just
That
because
interesting.
there are other issues
Hmm.
happening, or sometimes it's just ego. And so I would say just you don't want to do the deal incorrectly. If there's taxes involved, you know, I mean, how much are those taxes if a
Right.
seller has not paid? And as we know, that it does transfer to a buyer,
Hmm.
and it may be tens of
Between what
thousands
they
of
owe
dollars.
and penalties, it can
Yeah,
be huge. Yeah.
yeah. I mean, it could be more expensive than an attorney. And
Yeah.
then like the stress of having to deal with this or like this business that now has no value, or is just the stress of like, okay, like what do I do with these assets? And now I have this liability on top of that, and it's not worth it. And I've seen people come to me after the fact, and we have such limited options at this point because the
Yeah.
deal has been done, the seller moved, whatever.
Yeah.
So
Yeah.
I would say it is worth the money.
I agree. I agree. That's my position, but wanted to get it from your
Yeah,
perspective. One other
yeah,
question related to this, and then we'll start to wrap it up. But
sure.
I always get the question as well: is who should incur the cost of drafting the initial contract? Right now, my position has always been that depending on whether I'm the buyer or the seller, I want to be the one that drafts it because it's more likely that it's to my advantage, but that's just the way
Yeah.
I think about it. But is there a general practice, or does it vary state by state? Obviously, there's no law on this, but what's
Right.
customary here and what's recommended as to who incurs the cost of drafting it? And then, of course, we talked about, because that's another point of confusion. I've had a situation, for example, where we have one attorney that represents all of us as partners in that case.
Right.
And that attorney, of course, has to make it clear that he's representing the best interest of the business, not us individually. But let me break that down, because that was a compound question there.
Yeah.
Who, how should I look at who incurs the cost of drafting the contract?
So customarily it's the buyer, the buyer's counsel. Now, I mean, if a buyer has leverage, sometimes they can ask the seller to compensate them for those fees. I don't see that really too often, but it is usually the buyer like it's expected that the buyer drafts. So when I'm on
Okay.
the seller side, I double check with the buyer first, if they're going to draft. And usually
Yeah.
as a buyer, like we start that process pretty quickly. And I think the reason is, I mean, like from a logistical point of view, it makes sense because the buyer is incurring the risk. And so they probably want to start off with like how to protect themselves.
Hmm.
Sometimes the sellers want to for that same reason, but I think that in general, the buyer is probably incurring more long-term risk. So
Okay.
that's kind of the longer answer to your
Okay.
question.
That makes sense. The other point of confusion I want to come back to is I'll put it in a different scenario.
Sure.
I've seen people get confused. Well, the seller has an attorney and they're going to take care of it. So I don't need my attorney. Explain why that's potentially a mistake.
Oh, because the seller is going to do I mean, the seller's lawyer is going to do what's best for the seller. They don't really care about the buyer. The buyer's needs. So if you want something like a holdback, I mean, the seller is not going to suggest that to you. They're going to want to take all their money. The seller's attorney is going to put the least amount of indemnifications and representations. And so I think that's a terrible move. I don't know why people think that an attorney would represent both sides, but yeah, definitely. I mean, as a buyer, should definitely, yeah, get their own lawyer to
Yeah.
review and negotiate.
Absolutely. Absolutely. Is there anything else that comes to mind that we didn't talk about that's a big one that you're like, oh, Henry didn't ask me, or we should have talked about? I see
No, I
this as a
think
common mistake, or did we cover most of them?
no, from a legal perspective, I
Yes,
think
ma'am.
that's pretty comprehensive.
Okay. So tell us a little bit more about your services, the type of clients that you work with. Obviously, I mentioned a couple of things in the bio, but just recap for us. What is it that you specialize in, and what is the right type of potential client that should reach out to you?
Yeah, so anyone who likes to make deals, I like to see myself as a deal maker, not a deal breaker. So I'm the lawyer. I'm the good lawyer who wants to come or who helps you when you want to grow your business, or if you want to exit, you want to make that big, retirement move. So I'm the lawyer that people are usually excited, or at least not so sad to call. Um, and so, yeah, so transactions. I used to do some litigation, and I found that I just was not providing, or I could not provide the value that I was hoping to for those smaller businesses. And those are some pretty sizable businesses, just because how expensive and how stressful a lawsuit is.
Yeah.
And it's just so much more efficient and lack of stress to do things right the first time, so that if you're ever in court, you're protected, or you just like take that out of the picture altogether.
Right.
Um, so, I mean, the last thing you want to do is kill your livelihood over something that could have been, and I see this all the time, something small just turns into hundreds of thousands of dollars in legal fees and years of stress over honestly something that's just so minor. So in that sense, I like to so we help clients with mergers, acquisitions, and franchises, contract negotiations, and all the types of contracts that are involved. So like lease agreements, employment agreements, and all of those. We practice in two states here, in the state of Illinois and Florida. And that's pretty much sums it up.
Yeah.
We're
And
like a
what?
small,
Go ahead. I'm sorry.
like boutique.
Boutique firm. Yeah.
Yeah.
Where do we go online to learn more?
So it's motivalaw.com. And I got a blog that's pretty up to date. You can also see my YouTube channel, which is also on my website. It's youtube.com/Motiva Business Law. And there's a ton of great information to learn about me and my firm, and also my practice areas, and just a lot of great information.
Excellent. We'll have a link
Yeah.
to the website as well on the show notes page for this episode. So if you don't have you're not where you can write that down, just go to thehowofbusiness.com, look for this episode with Danya, and I'll have a link to that as well. I'm always looking for a book recommendation. Is there a book that you would recommend?
Yeah. So The Power of Habit by Charles Duhigg. It's not a legal book, but it really, for me, it's really opened my eyes to what a habit is. I mean, so the book starts with a story about a man who had brain surgery, and the point of that anecdote was that even his emotions were habits. And so I think as entrepreneurs, business owners, sometimes our reactions, our sadness, our fears are actually habits. And if we just stop and pause and understand how a habit is formed and why we take certain actions and why we react, then we can actually have more control and train ourselves to make better decisions, to slow down, to be more at peace. So I thought that was a great book.
Yep, that's a great one. Thank you for that recommendation. I'll have a link to it
Okay.
on the show notes page as well. All right, Danya, we'll wrap it up here. I always like to summarize it with a key takeaway of this conversation that we've had about legal considerations. We did look at it mostly from a buyer's perspective, but either way, summarize for us the takeaway that you want us to take about the legal side or legal ramifications or implications or considerations is probably the better word of buying or selling a business.
Just don't risk trying to do it on your own. I know it might seem obvious at this point in the conversation, but there are so many people have done what you've done as someone who's buying a business, and like engaging people who have done it before. You can use their expertise to avoid mistakes rather than making mistakes. So just at least talk to a lawyer, at least have a consultation and have them like walk you through the main mistake.
Yeah, agreed. All right, and tell us again what the website is.
It's motivalaw.com. So it's MOTV as in Victor, A law.com.
Perfect. Excellent. Danya, great conversation. Thanks for all of these insights. It's always tricky because I'm asking you to give me answers, but it depends, right? As an attorney. Yeah. So I appreciate you sharing these general guidance and tips and advice and experiences. Again, you must get your own attorney, and it's critical. I think it's critical, is what I advise to every single one of my clients is looking to buy or sell a business. I think if I had to summarize it as to that point, the key takeaway is what you spoke to save a little bit of money now, relatively speaking, for what it might cost you, not to mention the peace of mind that you have avoided all of the obvious mistakes or issues that could come down later. That is well worth the investment.
Yep.
All right. Thank you so much. I appreciate it. This is Henry Lopez, and thanks to all of you for joining me for this episode of The How of Business. My guest again today was Danya Shakfeh, and I release episodes every Monday morning. You can find the show anywhere you listen to podcasts, including at my YouTube channel, The How of Business YouTube channel, and the website, thehowofbusiness.com. Thanks again for listening.
Thank you for listening to The How of Business. For more information about our coaching programs, online courses, show notes pages, links, and other resources, please visit thehowofbusiness.com.